Hi, I'm John Oxenham, a director at Norton's Incorporated, a leading competition and regulatory firm in South Africa. The topic I'll be discussing is successfully negotiating the ever-increasing rise of government interventionism in South African and regional merger control. The reason why this is relevant is not that only does interventionism have the potential to undermine the independence of merger control agencies, but given the increasing trend of government intervention over the past decade, there are concomitant negative effects on merger control in terms of timing and costs. The number of countries in sub-Saharan Africa, and indeed Africa as a whole, which require mandatory merger notification has increased dramatically in recent times. South Africa, which is the largest economy in Africa and has had a merger control regime in place for some time now, has made significant contributions to merger jurisprudence in sub-Saharan Africa already. Accordingly, as many regional countries adopt competition law legislation or specific merger control regimes, they will look increasingly towards South Africa's competition authorities to assist in interpreting and enforcing competition law policies. In addition, with this growth in regimes, there are significant challenges for companies and advisors on their behalf in engaging in multi-jurisdictional mergers, principally due to the fact of the lack of uniformity across the respective jurisdictions. In particular, when one considers the unique merger control review considerations that the South African authorities take into account, it becomes clear that navigating through the field of merger control in South Africa, and indeed many African countries, requires great skill and care. While South African competition law contains many of the fundamental elements embodied in the more established jurisdictions of developed countries, it also contains elements which are the product of South Africa's economic, social and political history. These unique elements have given rise to so-called public interest considerations. There are a number of African countries who also contain public interest considerations, including Namibia, Botswana, Zambia, Kenya, Swaziland, Malawi, and COMESA, which is the acronym for the Common Market for Eastern and Southern Africa. COMESA strives to operate as a broad, overarching competition authority when there is economic activity in more than one member state, much like the European Commission and the European Union. While the focus of this discussion will be based on a South African perspective, it will, however, be wise to take cognizance of the developments in the other jurisdictions, as many international companies operate in more than one African market and are required to notify beyond South Africa. So why is government intervention a cause for concern? In South Africa, the main point of access for intervention in merger control comes from the wording of our Competition Act, which, as already mentioned, includes the consideration of public interest factors as part of merger assessment. Moreover, the Act specifically caters for third-party intervention. In relation to the development and scope of government intervention in merger proceedings, the competition authorities have perhaps not dealt with this largely novel concept, as far as many developed countries are concerned, in the most pragmatic and efficient manner possible. In this regard, the risks of increased government intervention are significant. Firstly, it generally leads to a lengthier process and increased costs, which could practically hinder mergers that would otherwise be beneficial for society as a whole. Secondly, increased intervention also leads to uncertainty, which is detrimental to potential foreign investors actually wanting to enter into the South African economy. These risks pose practical concerns arising from increased interventionism that must not be underestimated. I'll briefly outline the applicable sections of the South African Competition Act before discussing the developments that have taken place over the past decade regarding the approach that the competition authorities have taken in merger control. I will also illustrate the effect of government intervention in light of the traditional pure competition tests as opposed to the public interest inquiry, which seems to have increasingly become the focus of the competition authorities of late. Firstly, Section 2 of the Competition Act makes it clear that the purpose of the Competition Act is to promote and maintain competition. This is not surprising and is consistent with most competition legislation in other jurisdictions. However, there are additional objectives, such as promoting unemployment and promoting the spread of ownership, which is aimed at addressing the historically disadvantaged people of South Africa, which perhaps distinguish South Africa's Competition Act from those of most of the OECD members, such as the US statutes or the European Union's merger regulation, which is centered pretty much solely on an assessment of the effect of a merger on competition and hence consumer welfare. Chapter 3 of our Competition Act deals with merger control and in particular notes that in addition to a competition test, a public interest test must also be undertaken. More specifically, the Act states, when determining whether a merger can or cannot be justified on public interest grounds, the Competition Commission or the Competition Tribunal must consider the effect that the merger will have on A particular industrial sector or region, B, employment, C, the ability of small businesses or firms controlled or owned by historically disadvantaged persons to become competitive, and D, the ability of national industries to compete in international markets. There are, of course, broader objectives in purely maintaining or promoting competition in the economy. Thus, it is clear that the competition authorities must be notified of the merger and will then apply a two-stage test. The first, which is a pure economic test, seeks to ensure that competition will not be substantially lessened by the merger, and if it is, to ensure that such a lessening is justified in relation to the efficiency or technological advantages that the merger would create. The second test is a public interest inquiry, which requires the merger to be justified on public interest grounds. An anti-competitive merger can be sanitized by its positive impact on the public interest factors. A pro-competitive merger can be prohibited on the basis of negative public interest implications. Following consideration of a merger, the competition authorities are obliged to either approve the merger subject to conditions, or prohibit the implementation of the merger. The competition authorities are vested with wide powers, particularly in respect of the implementation of conditions which may extend beyond those aimed strictly at promoting competition and which may extend into the realm of the public interest. This, as we will see when discussing recent case law, has become increasingly prevalent, in particular when a merger has potentially negative consequences relating to employment, such as planned retrenchments. While it is easy to sympathise with the authors of the Competition Act, and indeed the employees affected by large-scale retrenchments, it is important not to take too short-sighted a view of the effects of interventions on these bases, which are often driven by government departments or trade unions. Short-term retrenchments may seem at odds with the public interest, particularly in a country like South Africa, which has a limited social safety net, and workers often have limited skills and training. However, if a merger or series of mergers promotes, grows and stimulates the economy by attracting foreign investment, allowing firms to operate more efficiently and providing a greater benefit to consumers, basic economic principles coupled with logic suggest that a growing economy will positively address unemployment. However, should an economy fall stagnant or foreign investors be excluded from the South African market due to the number of public interest hurdles that have to be overcome, the negative impact on employment, economic growth and consumer welfare will significantly outweigh the short-term gains. This is the single most striking dynamic that is seldom acknowledged, much less applied in considering the balance between pure competition objectives and the so-called public interest considerations. It is, of course, very difficult for the South African competition authorities to consider the long-term and short-term effects on a case-by-case basis. A greater reliance on a pure competition test to a large extent alleviates this problem, as a pure competition and efficiency focus is likely to have positive long-term benefits for growth and employment. The short-term impacts in reducing the costs of investigation and uncertainty for investors provide another strong motivation for a focus on a pure competition test. A greater focus on a pure competition test is also sound from an administrative perspective. By reducing the scope for subjective discretion by the authorities, one removes a huge part of the incentive for prolonged, costly and self-serving intervention. However, in recognition of the broader social setting of South African and regional merger control, rather than restrain and limit the classical antitrust-based legal context, the South African Competition Act gives extensive rights to third parties to participate in merger proceedings. This is important particularly in relation to international transactions. Section 53 of our Competition Act sets out the categories of persons who may participate in merger proceedings, which includes the merging parties, the Competition Commission, and, in certain circumstances, the relevant trade unions and the ministers of various departments. Furthermore, there is a broad residual category in Section 53 which provides that any other person may participate in merger proceedings if the tribunal recognizes them as a participant. Section 13A2 of the Competition Act requires that the merging parties forward a copy of the merger notification on to representative firms, employees, trade unions, or employee groups, presumably so that the relevant union or employees group can decide whether or not to intervene in the merger control proceedings. The express recognition of employment impact as a public interest in terms of Section 12A of the Competition Act, along with the obligation on merging parties to notify trade unions of a merger, is most likely the reason why so many approved mergers of late have been granted subject to stringent conditions relating to the protection of current employees. The South African Competition Act has also furthermore been reluctant to shut out third parties from intervening in merger proceedings, and has demonstrated a willingness to receive third-party evidence relevant to its understanding of the relevant markets from customers, suppliers and competitors, and to permit the intervening party a wide scope to participate in the merger control proceedings. The extensive participatory rights granted by the Competition Tribunal to third parties have, in some cases, allowed the extensive pursuit of non-competition objectives. However, as discussed further above, there is a risk that the consideration of the public interest issues, and in particular the effect on employment, does not necessarily promote employment if it jeopardizes the growth of the economy. Although the Competition Tribunal has rules which limit the participation of third parties to those with a material interest in the proceedings, the rules are subject to the Competition Act, and since the Act does not require a third party to demonstrate a material interest, the rules cannot impose such a requirement, meaning that in actual fact, it is particularly easy for a third party to intervene in proceedings and, by implication, unnecessarily delay the process. Considering that the effectiveness of mergers is largely determined by timing, the potential for third parties to abuse the proceedings is self-evident. There is little doubt that this procedural element has provided significant scope to the trade unions and government, again, with a negative impact on the timing, uncertainty and cost of global mergers in South Africa. The policy justification for third-party intervention is perhaps also not as applicable today as it was 15 years ago. For example, the former chairperson of the South African Competition Tribunal, David Lewis, has acknowledged the importance of intervention, particularly in respect of a young authority which benefited from the extra information and evidence placed before it. David Lewis said, "The broad standing to intervene is also driven by the unique quality of information and analysis that knowledgeable insiders are able to bring to inquiries as fact and context specific as merger inquiries." This was particularly so in the early years of the South African Competition Commission's life. However, these benefits to interventionism do not come without a cost, and now that the competition authorities in South Africa have greater specialist experience and are arguably more qualified, there is an argument that there is less need for intervention than there might have been previously. Be that as it may, a brief overview of the developments in South African merger control case law clearly indicates an increasing tendency by the competition authorities to permit government intervention in merger control proceedings. As a point of departure, the initial approach of the South African Competition Tribunal in relation to the case law regarding the public interest and the impact of the public interest is important. This is well illustrated in the following three cases. Firstly, in the Shell South Africa TEPCO Petroleum case, the South African Competition Tribunal considered the primary objectives of the Competition Act to be the promotion and maintenance of competition in the market. The Tribunal stated the following: the Commission's role is to promote and protect competition and a specified public interest. It is not to second guess the commercial decisions of precisely that element of the public that is enjoined to defend, particularly where no threat of competition is entailed. The Tribunal went further by stating, the role played by the competition authorities in defending even those aspects of the public interest listed in the Act is at most secondary to other statutory instruments. The reluctance of the Competition Tribunal to attach significant weight to public interest considerations was confirmed in the second example, which is the Distillers Corporation Pty Limited versus Stellenbosch Farmers Winery Group. In that case, the matter specifically addressed the relationship between public interest consideration and competition issues. The Tribunal had the following to say: where there are other appropriate legislative instruments to redress the public interest, we must be cognizant of them in determining what is left for us to do before we can consider whether the residual public interest that is part of the public interest not susceptible to or better able to be dealt with under another law is substantial. The tribunal made the following apt remark: public interest is a policy at war with itself. The third case, which highlights the original approach of the tribunal, is that of the Unilever plc and the Competition Commission of South Africa matter. In this case, it was not the government, but importantly, as will become apparent further on, a trade union that intervened as a third party and contested Unilever's proposed merger from the viewpoint that the merger would have had a significant detrimental effect on existing employees. The tribunal, while imposing certain conditions regarding the dismissal of employees once a merger was approved the merger and held, importantly, that competition law or the competition arena was not the appropriate mechanism to address trade union concerns. It held that the trade unions had other means available, and in particular labour law legislation, which would have been a more appropriate tool to address those concerns. However, 9 years after the Unilever plc decision, it is clear that the Competition Tribunal has dramatically changed its stance in relation to the importance attached to the public interest considerations. In the matter of Metropolitan Holdings Limited and the Momentum Group, the tribunal embraced the public interest analysis. Despite no competition objections being raised against this proposed merger, the intervening trade union in this case successfully convinced the tribunal to impose certain conditions on the merger to avoid large-scale dismissals. The tribunal made the following observation: the prioritization of the competition inquiry explains the use of the word justification in the public interest test. The public interest inquiry may lead to a conclusion that is the opposite of the competition one, but it is a conclusion that is justified not in of itself, but with regard to the conclusion on the competition section. In respect of whether a proposed merger could be prohibited purely on public interest grounds, the tribunal expressly stated the following: yes, it is possible that a merger that will not be anti-competitive can be turned on public interest grounds, but that does not mean that in coming to the conclusion on the latter, one will have no regard to the conclusion on the first. Hence, Section 12A makes use of the word justified in conjunction with the public interest inquiry. In this case, the tribunal imposed significant public interest conditions on the merger, which was deemed non-problematic from a pure competition law perspective. These included a moratorium on all merger-related retrenchments for a period of 2 years subsequent to the transaction. This was despite an undertaking by the merging parties to provide support, including core skills training to affected unskilled and semi-skilled employees, outplacement support and counselling, and for the merging parties to use their best endeavours to redeploy affected employees within the merged entity. While the cases referred to so far involved largely domestic South African companies, the impact of public interest considerations in respect of international companies seeking to enter the South African market became apparent in two important recent cases. The first is the Kansai Paint Company Limited and Freeworld Coatings. In the matter, the merging parties were faced with opposition by the South African government on public interest grounds. The matter related to the hostile takeover by Kansai, a coating manufacturer, of Freeworld, a local manufacturer and distributor of decorative and performance coatings. The Department of Trade and Industry had made a number of submissions to the Competition Commission during the merger review in respect of the transaction. In particular, the DTI had argued that the takeover constituted a direct threat to government's localization initiative, since Freeworld, which was a local entity, was the only local manufacturer of automotive coatings supplied to the domestic automotive industries. The DTI also raised concerns regarding the effect of the takeover on employment levels, black economic empowerment, and the impact of the takeover on innovation markets and affording direct investment. The Competition Commission found that the takeover gave rise to no competition concerns, but approved this takeover transaction subject to a number of wide-ranging welfare and public interest conditions, which included a prohibition on merger-related retrenchments for a period of 3 years, a condition ordering Kansai to divest of Freeworld's entire automotive coatings business. The condition that Kansai continued to manufacture decorative coatings for 10 years and invest in research and development with respect thereto. That Kansai implemented a broad economic empowerment deal within 2 years of the takeover, and that Kansai established an automotive coatings manufacturing facility in South Africa within 5 years. Kansai, obviously dissatisfied with these conditions, referred the matter to the Competition Tribunal for a consideration. The DTI applied for formal intervention in terms of the legislation that I articulated earlier in the proceedings themselves, but subsequently withdrew its application to be recognised as an intervener when the Commission undertook to present the concerns that the DTI had expressed directly to the Tribunal. The parties thereafter entered into settlement negotiations, and the matter was ultimately settled. During the settlement hearing and approval ultimately of the transaction, the following statement was made by the Tribunal. We failed to find any substantive anti-competitive effects to the merger that could not be addressed by the revised agreed to conditions, and that the dire condition of a divestiture initially required of the merging parties was found to be unwarranted. In addition, conditions relating to merger-related public interest concerns, such as employment, the development of local manufacturing, with concomitant research development, were agreed between the Commission and the parties. In effect, the South African Competition Tribunal elevated public interest considerations to such an extent that a pro-competitive merger could have been prohibited if the effect on the transaction on employment in the relevant sectors is not adequately addressed by the merging parties. This brings us to the well-publicized Massmart Holdings and Walmart Stores merger, undoubtedly the seminal case in South African jurisprudence concerning the public interest criteria, as well as the potential impact that government interventionism can have on merger control in South Africa. This was a merger between Walmart, a well-known international retail firm who wanted to enter into the South African market by way of merging with Massmart, which was a well-established retail company in South Africa. In the matter, third parties who intervened included a number of governmental departments, including the Minister of Trade and Industry, the Minister of Economic Development, the Minister of Agriculture, Forestry and Fisheries, as well as third-party intervention from 5 trade unions. Importantly, the intervention was largely brought about by the fact that the South African Competition Commission had recommended the merger be approved unconditionally. The primary public interest aspect that was raised by the intervening parties was that this merger would have a negative impact on local procurement, which in turn would lead to job losses. The South African Competition Tribunal ultimately approved the merger subject to certain conditions, but did not place too much weight on the public interest concerns which were articulated by the intervening parties, namely the government ministers and the trade unions, primarily because it found that Walmart was not a competitor on the South African market, and also that there could not conceivably be significant issues of concern. Despite the conditions that were imposed and those which also related to public interest, the ministers who had intervened were dissatisfied with the outcome of the proceedings and took the matter on appeal to the Competition Appeal Court. The Appeal Court again approved the merger, but held that the merger did give rise to significant public interest concerns, which ought to have been addressed in the conditions attached to the Competition Tribunal's approval. The Appeal Court held the introduction of the largest retailer in the world to the South African economy may pose significant challenges for the participation of South African producers in the global value chains, which, as the evidence indicates within the retailing sector, is dominated by Walmart. Failure to engage meaningfully with the implications of this challenge posed by globalization can well have detrimental economic and social effects for the South African economy in general and small and medium-sized businesses in particular. As a result, the Competition Appeal Court partly upheld and partly supplemented and modified the conditions imposed by the tribunal. In doing so, it sent a clear message that the competition authorities must take Section 12A of the Competition Act duty seriously, namely to weigh the public interest considerations in relation to merger control very seriously. The Appeal Court stated the following: manifestly, competition law cannot be a substitute for industrial or trade policy. Hence, this court cannot construct a holistic policy to address the challenges which are posed by globalization. But the public interest concerns set out in Section 12A demands that this court give tangible effect to legislative ambition. Despite the significant amount of parties who intervene in this matter, despite the acknowledgements the Competition Tribunal and the Competition Appeal Court made regarding the public interest issue, and despite the fact that the merger was ultimately approved, there is a practical reality that cannot be ignored, and this is particularly apposite in relation to international transactions. The reality is that this merger took more than 12 months to finally be approved, subject to stringent public interest conditions removed from competition law. This is despite both the Competition Commission, Tribunal and Appeal Court finding that the proposed merger did not have an actual impact on competition. This delay is undoubtedly due to the large number of intervening third parties and especially the intervention of the three ministers. The conditions that were ultimately imposed on the merger included an undertaking by the merging parties that no retrenchments would take place for a period of 2 years and that 200 million rands or $20 million would be injected into a program to develop small businesses. While these conditions are onerous and the restriction on retrenchments in itself will often negate any economic or competitive advantage in a proposed merger, there seems to be little evidence that these conditions alone will actually protect or promote the public interest issues at stake. In Namibia, the same Walmart merger was scrutinized by the Namibian Competition Commission authorities as it impacted on the Namibian economy. While the merger was ultimately approved, the following conditions were also imposed. There were to be no retrenchments for 2 years, existing labor agreements between the trade unions and the merging parties had to be recognized, and also there was an obligation to develop domestic supplier activities. Based on a review on the above case law and the South African and regional case law, both competition authorities in South Africa and regionally are increasingly relying on the public interest considerations and imposing conditions on mergers which would otherwise not have been the case. What is the relevance of the relationship between government intervention and the public interest considerations? The pattern which has emerged in recent cases is, in our submission, largely driven by wider government policies. Minister Ebrahim Patel, the current Minister of Economic Development in South Africa, has played a significant role in pursuing so-called non-competition or public interest considerations. In 2009, the South African Competition Commission's portfolio status changed from being beneath the Department of Trade and Industry to being beneath the Department of Economic Development. Coincidentally, the same year that Minister Patel was appointed to be the Minister of Economic Development. Minister Patel has been involved in many of the highest profile cases involving public interest considerations. He was appointed as the General Secretary of the South African Clothing and Textile Workers Union in 1999 and is also one of the founding members of the Congress of South African Trade Unions, South Africa's biggest trade union. It's important to sketch Mr. Patel's involvement, or Minister Patel's involvement in merger proceedings prior to him being made a minister. In 2003, Minister Patel represented Satawu during the Dawn Etsai and Colossus Holdings Limited merger. During the tribunal hearing, Minister Patel, or Mr. Patel as he then was, argued for the imposition of 3 public interest conditions. Firstly, that the same levels of employment prior to the proposed merger should be maintained. Secondly, that the merger parties maintain the pre-merger level of wages and employment conditions. And thirdly, that the tribunal impose a condition that would oblige the merged entity to continue its membership of the applicable industry-wide centralized collective bargaining system. Despite Mr. Patel's submissions, the tribunal did not, however, impose these conditions. In 2004, Satawu made submissions during the proceedings in Bid Industrial Holdings Limited and G. Fox & Company merger, which led to the merging parties providing an undertaking that no unionized employees would be retrenched for a period of 18 months from the effective date of the merger. During the tribunal hearing, Satawu could not proffer, this is the union which Mr. Patel was representing, could not proffer up any evidence that the merger itself would lead to retrenchments of certain individuals and furthermore, it failed to show that the merger would lead to retrenchments of employees. The tribunal accordingly did not impose any conditions on the transaction. 2 years later, Mr. Patel, again on behalf of Satawu, intervened in the Edcon case, a proposed merger between Edgar's consolidated stores and the entity Rapid Dawn 123. Satawu intervened based on Edcon's alleged procurement policy. In an interesting and portentous parallel comparison, Mr. Patel, as he then was, compared Edcon to Walmart in the United States, claiming that Edcon, like Walmart, was focused on increasing its imports, thereby impacting negatively on employment in the domestic clothing and footwear industry. Satawu proposed a condition of a cap on Edcon's purchases of imports, or at least in the target firm. The tribunal did not, however, impose conditions on the merger, stating that Satawu's concerns about cheaper imports cannot be cured by the imposition of a merger condition on a single firm. It is a sector-wide phenomenon and must be addressed at that aggregated level with the appropriate instrument. Minister Patel's intervention in international mergers has been well documented in various articles and papers, and is regarded locally and internationally as some of the more striking examples of government intervention in merger proceedings. Due to the intervention of, inter alia, Minister Patel in his capacity as the Economic Development Minister, significant conditions were imposed, as discussed earlier on in this presentation, on the merging parties in the Walmart-Massmart merger. Due to the involvement of the DTI in the Kansai Paint Free World merger, the Competition Commission not only imposed conditions relating to competition issues, but also conditions relating to employment, industrialization, and black economic empowerment. Minister Patel commented in that case that the South African government was encouraged by Kansai's approach, and the fact that it took to heart the government's new growth path strategy. More recently, in the highly publicized Agri-Group Afgri transaction, the parties were forced, undoubtedly, in order to enable the parties to meet deal deadlines, into a private side deal between the South African government, which effectively sidestepped the Commission's jurisdiction and decision-making competence. In terms of the deal, Afgri was obligated to make available 90 million rand, $9 million, over 4 years to certain South African farmers and enroll emerging farmers in development programs and to assist local poultry farmers. Looking forward, what are the practical impacts that increased government intervention has on both domestic and international transactions and on merger control in South Africa? The Walmart and Kansai mergers illustrate the significant impact that government intervention can have on international firms wanting to invest in South African market, and the current scope of intervention, which is putting at jeopardy effective merger control. It now appears that parties are engaging in side deals with government departments in an effort to avoid the lengthy and risky merger control assessment being made more risky by government intervention. Unfortunately, sound and good merger control depends on what the International Competition Network identified as the three fundamentals, namely timing, costs, and certainty. Extensive public interest considerations and increased government intervention put at risk each of these three fundamentals. As pointed out already, the public interest factors are broad, and the ease at which third parties can intervene in proceedings increases the scope of abuse by parties, who will achieve their objectives by simply ensuring the merger application is denied. Uncertainty and lengthy procedures have an obvious negative impact on costs as well. These include not only direct legal costs, but also indirect costs and economic opportunity losses. The lack of certainty is a significant deterrent for foreign investors who want stability and clarity with respect to the rule of law before making substantial investments in South Africa. The practical advantages of increased foreign investment are self-evident, but notably, it will increase employment as the economy grows. All of these costs must also be taken into consideration when determining what's in the public interest. For the above reasons, a pure competition law test is perhaps still a more suitable approach. While third-party intervention is clearly an important tool to ensure fundamental public interest issues are not ill forgotten, placing a greater emphasis on a pure competition test could, in of itself, serve as a mechanism to ensure that third-party intervention, and especially government intervention, does not become overly burdensome at the expense of mergers that would otherwise benefit consumer welfare and stimulate the general economy. Due to the broad range of factors that could potentially fall within the public interest, increased government interventionism also places the independence of the competition authorities at risk. As ex-Commissioner Rambo stated in 2013, "We are a completely independent institution. I am a completely independent individual. But are politicians trying to use us, exploit us for political agendas?" "Yes," he answered. Unsurprisingly, the ex-commissioner was unceremoniously forced to exit the commission in 2013. It is therefore important to have proper and clear guidelines in place to ensure consistency, transparency and certainty is promoted. The South African Competition Commission has recently published for comment guidelines on the assessment of public interest provisions in merger regulation under the Act, which sets out the general approach the Commission should use when assessing public interest provisions. The guidelines are fairly basic, but at least set out the high-level framework for such an assessment, and with few surprises. For example, it is reiterated that the public interest must be merger-specific. If not, then the inquiry should end there. The public interest must also be substantial. Thus, if there is no causal link between the merger and the effect, or the effect is not substantial, the inquiry should end there and then. The guidelines are welcomed insofar as they attempt to provide some certainty and clarity with respect to the way in which the Commission will approach the public interest. Unfortunately, the guidelines also raise a number of concerns. In particular, Section 8.1 of the guidelines state that the Commission will evaluate the effects of a proposed merger has on employment, but where there are merger-specific job losses at issue, a case-by-case evaluation must be done. This is problematic for a number of reasons. Firstly, it presupposes that there need not be a nexus between the merger and employment issues before the Commission will intervene. This section, like most of the guidelines, is very broad and ultimately leaves the Commission with broad discretionary powers when evaluating the impact of the merger on employment. It is thus debatable whether the guidelines will in fact address the concerns that have already been raised. In concluding, recent developments in merger analysis by the South African competition authorities demonstrate an increasing influence of intervention by government ministers and an increasing prevalence of public interest theories of harm in merger